Pursuant to Standing Order 108, Sub 3, the committee is meeting to continue its study of Bill C-25, an act to amend the Canada Elections Act, and an act to change the names of certain electoral districts, 2026. Today's meeting is taking place in public in a hybrid format pursuant to the standing orders. Members are in person in the room and have the option to appear remotely on Zoom. Before I continue it, I'd ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and for help protect the safety of everyone, including our interpreters. There's a QR code. Please watch the video. I'd like to remind witnesses that committee members may ask questions in either English or French. If you need interpretation, please take a moment now to prepare your earpiece and select the listening channel you need in advance in order to take full advantage of the time allotted for questions and answers. Just a few comments for the benefit of members. All comments should be addressed to the chair. If you're in the room or on Zoom, please raise your hand and we will do our best to call on you. I would like to welcome our witnesses for today's first panel. As individuals, Gerard Chippier is a lawyer, Yves Gamond, a lawyer and PhD student, and Peter Lowen, the Harold Tanner Dean of the College of Arts and Sciences, Cornell University. Welcome to everyone. You will each have 5 minutes to deliver opening remarks. We will start with Mr. Chippier. 5 minutes, please.
Thank you very much. Members of the committee, in my submissions, I plan to address 4 edits that I believe will improve Bill C-25. But before I address those edits, I would like to state that Bill C-25 will significantly improve the protection that Canadians have with respect to the electoral process and will increase the protection from hostile state actors and others outside Canada desiring to influence Canadian elections. So thank you for those proposals. I would also like to remind the committee of my previous recommendations that the nomination process should not be governed by the Canada Elections Act. So I continue to recommend that nomination processes be left entirely to the parties, and that is something that I continue to recommend because it is my view that in its current form, the Canada Elections Act continues to violate Section 3 of the Charter in the manner highlighted by Justice Epstein of the Ontario Supreme Court. In 1999, in the Galati and Ontario Liberal Party, Justice Epstein said this: "It is apparent from authorities that, contrary to the plaintiff's claim, the intervention of the government in the nomination process of political parties would constitute a breach of constitutional rights." I think he was right then, and I have seen no cases that would challenge that conclusion. Now to the 4 edits. First, I recommend the removal of certain unnecessary red tape. Second, the preservation of the neutrality of the administration of the Canada Elections Act. Third, the prevention of certain fraud and abuse. And fourth, the protection of freedom of expression. My first point is on the question of privacy. It is my view that we do not need amendments related to privacy. In my view, the cure is worse than the disease. The publication of voter names and addresses has never been a problem in the past. At least I'm not aware of any problems. No harm has come from that. And in any event, there are thousands of people across Canada who have these voter lists, and nothing has come from it. I recommend that you don't go there, but likely you will. So if you do, my recommendation is that at least delete your proposed Section 385(2)K and Section 387 of the Canada Elections Act because they are duplicative. There is no need to have a role for the Chief Electoral Officer if you already have it statutorily set forth. The statute sets forth in Section 446.6 the rules that will apply, but then says a political party must have a policy and that the chief electoral officer has a role in approving that policy. My view is there should be no role for the CEO. There should be no policy. Just follow the act if you're going to have rules related to privacy. And there's a Court of Appeal decision on that, Longley in Canada, 207 Ontario Court of Appeal, but I won't read that because of the limitations of time. Another very important change is with respect to neutrality. Right now, the Act allows the commissioner to proceed to investigate and require testimony under oath without judicial review. That is problematic because it gives the commissioner the opportunity to move forward without an independent third party saying, yes, there's enough evidence here to interfere with the right of the subject that typically is in place with respect to criminal law to remain silent. It just doesn't make sense to allow the chief electoral officer to have that, or the commissioner to have that kind of power. My view is the rules in Section 510.01 that require judicial review should apply to any of the investigatory powers exercised by the commissioner. I have three great recommendations for the issue of the abuse of the ballot. And I know I'm probably over time.
10 seconds.
Okay, three. One is require 200 signatures instead of 100. Secondly, take out the limitation in 477.2 to the same electoral district. And third, my recommendation is in your ballot, have the parties listed first in alphabetical order, and of course, changing with each ballot. So you have the parties listed first and all individuals listed second. Therefore, you're able to allow individuals to make a wise choice if they choose to. And I'll stop there.
Thank you so much. You'll have plenty of opportunity to expand on that. We will now go to Ms. Gaumond, please. 5 minutes.
Thank you, Mr. Chair, and thanks to the committee for the invitation to contribute to your discussions on the Canada Elections Act. Mon nom est Eve Gaumond, je suis avocate et doctorante à la...
My name is Eve Gaumond. I am a lawyer and a doctoral student at the Faculty of Law of the University of Montreal. My research focuses in particular on the Canada Elections Act and the preservation of electoral integrity. I served as a guest expert at the Citizens Assembly on Democratic Expression as part of Election Quebec's work and during the Canada-Netherlands consultations on the Global Declaration on the Integrity of Online Information. I have also taught privacy law at Université Laval. Bill C-25 is a good bill. It is not perfect. In terms of privacy protection, it falls far short, and improvements could be made regarding the transparency of online political activities. But at a time when trust in democratic institutions is eroding, it is important to focus on one thing. Even though there is always room for improvement, the current legal framework is robust and resilient, and it has effectively protected the integrity of Canadian elections to date. My comments will focus on the two aspects of the bill that I believe warrant improvement: the privacy regime and the transparency mechanisms designed to ensure the integrity of online political activities. Given the time I have, I will briefly touch on each area for improvement, but I have submitted a list of written recommendations to the committee, and I will be happy to elaborate on them further during the question period. Regarding the issue of personal information protection and privacy, we must draw a line between what falls under the Canada Elections Act and what falls under privacy laws. These are two legal frameworks that serve different functions. The purpose of the Canada Elections Act is to establish the rules of the game to ensure the integrity and proper conduct of elections. It is entirely appropriate that it includes offences concerning certain problematic practices in a political context, such as selling personal information held by a party or disclosing personal information to cause harm, for example. Section 36, for example, is relevant. That said, the Canada Elections Act cannot be used to create a comprehensive and exclusive national privacy protection regime. The right to privacy is a complex and technical field that cannot be addressed in passing within a legislation dealing with other matters. It is therefore essential to repeal sections 446.2, 446.3, and 446.4 so that existing provincial privacy laws can apply to federal political parties, at the very least until a truly comprehensive national regime is established. The federal law should seize this opportunity to bring federal political parties under this regime. It is concerning that political parties are the only Canadian organizations not subject to the basic privacy rules, especially when we recall that the Cambridge Analytica scandal essentially revolved around the use of personal data for political influence. Now, regarding transparency. The elections legislation is largely based on the idea that transparency promotes integrity. This principle holds true in the real world. But to ensure that the activities in the virtual world meet equivalent transparency standards, 3 measures should be considered. First, adapting certain existing regulations to the reality of artificial intelligence. When a party uses automated calling systems, it must register with the CRTC and submit a list of the phone numbers contacted, along with a copy of the recorded message or script that was used. Parties that use chatbots to communicate with voters should, at a minimum, be required to provide the prompts used to program the chatbots, as well as a list of the voters who were contacted. Political parties should also be required to disclose when they share content that has been generated or significantly altered by an AI system. The second has to do with influencers who are playing an increasingly important role in the political sphere. Currently, they often fall outside the scope of traditional transparency rules. The addition of a specific regime to govern campaign expenditures offered in exchange for endorsements should be considered. Such a regime could include a requirement for influencers to label sponsored content and disclose any significant ties they have to a political entity, including benefits and incentives. The final change concerns digital platforms. Section 325.1 should be amended to require major platforms to play a greater role in promoting transparency in online political activities. This means the government should collaborate with researchers and platforms working on election integrity issues and to codify expanded transparency obligations. These obligations must ensure that researchers can access the data needed to study Canada's information ecosystem, regardless of the political affiliations of the people leading these platforms. Thank you.
Merci.
Thank you so much. Now turn to Mr. Lowen for 5 minutes, please.
Thank you very much to the committee for this invitation to appear. I understand the committee is considering questions related to electoral district naming, including proposals affecting a small number of constituencies with Indigenous names. I'm grateful for the opportunity to comment on this issue, and I hope I can be helpful to the committee in its consideration not only of these particular cases, but also broader questions surrounding the naming of ridings in Canada. I want to make 3 points in the time that I have. First, there are good reasons for including more Indigenous names in our constituencies. Second, the process for considering Indigenous matters during boundary redistribution could be revisited. Third, the process or the practice of naming constituencies could likewise be reconsidered. I've appeared before this committee several times, usually on the basis of my expertise as a scholar of elections, electoral systems, and democracy. I gather I'm here today as one of 3 commissioners who is responsible for redrawing Ontario's federal boundaries in the last process in 2022. I did take occasion to consult with the other 2 commissioners, Madam Justice Leach and Professor Bird, and they're largely in agreement with what I have to say here today. It was an honor and a privilege for all of us to take part in that work and to serve Canadian democracy in that way. As part of that process, my fellow commissioners and I believed it was important to better recognize Indigenous peoples and histories in constituency names. The substantive representation of Indigenous peoples is explicitly considered in redistribution law and jurisprudence. The naming of constituencies is much less systematically addressed. I'll return to that point below. My first point, though, is that there are good reasons to include more Indigenous names in our constituencies. The first is that Indigenous place names are already deeply embedded in Canadian political geography, even if we do not always stop to notice. Mississauga, Skeena, Nanaimo, Temiskaming, Etobicoke, even Brant. These names derive from Indigenous languages, Indigenous peoples, and Indigenous history. They are familiar to Canadians. They are understandable to their communities. And they remind us that our political geography did not begin with Confederation. The second reason is reconciliation itself. This asks us, at least in part, to share more fully in the history of the country. It asks us and asks Parliament to strive to make our institutions places where Indigenous history and representation are visible and able to thrive. Parliament is an institution for all the peoples of Canada. It becomes more fully Canadian when it incorporates more of the histories and traditions of this place, not out of guilt or shame, but out of a desire to better reflect the country we actually inhabit. Part of this process, I hope, is that Indigenous names and writings may encourage Canadians to learn more about the Indigenous past and present of the places where they live. I'll give you just one example. It's humbling for me to think about what may have gone through the mind of Etienne Brule as he traveled down the Humber River toward Lake Ontario, becoming likely the first European to see the Great Lakes. Shortly before reaching the lake, he likely would have encountered the area and the people around Taiayakon, a large and sophisticated Indigenous settlement near the river. Looking toward the lake, he would have seen a landscape very different from the one we know today. Long houses, cultivated land, black oak savanna, and burned grasslands where High Park now stands. This was a civilization long before it was Babby Point. We recognize and remember things by naming them. On the process, 2 points. First, the redistribution process is sequenced in a way that maps are drafted and ridings named before public consultations occur on particular recommendations. The sequencing could perhaps be revisited by Parliament and by future commissions, though it would be difficult to change in practice. It's hard to consult on particular riding names until an entire map has first been constructed, but perhaps a different process is possible. Second, members might consider whether Parliament should routinely alter names recommended by independent commissions after redistribution has concluded. You might also consider whether changing riding names is the first step to changing other features of ridings after the process has concluded. MPs should not, I contend, get to name their own ridings, which might be a fair characterization of what is happening here. I'd be happy to discuss that point further. And now a final observation. Ridings do not necessarily have to be named after places. Australia commonly names electoral districts after historical figures, and provincial ridings in Quebec, for example, often follow a similar practice. There's much to recommend that approach as well. I personally think there's value in the geographic naming of ridings because our electoral system remains, at least in part, a system of geographic representation. I hope these remarks have been helpful. I look forward to your questions. Thank you.
Thank you so much. We will go to Mr. Cooper for 6 minutes.
Thank you, Mr. Chair. Thank you to the witnesses. I'm going to ask some questions to Mr. Chippier regarding third-party financing. As you noted, the bill closes certain loopholes in the Canada Elections Act that have been exploited by foreign actors and certain registered third parties in terms of foreign actors and foreign interests being able to fund registered third parties for regulated activities. In that regard, the bill as a general rule requires registered third parties to set up a separate bank account for regulated activities with the stipulation that contributions to that bank account only come from individual Canadians. However, there is an exception where third parties can use their own funds for regulated activities if contributions constitute 10% or less of the third party's revenue in the year prior to the pre-election period. According to the Chief Electoral Officer, where this exception applies to a third party, the funds used by the third party would be treated as commingled, whatever the source. So that could mean contributions from a foreign source, hypothetically. Would you agree with this third-party exception in the bill, the 10% exception, loopholes that have enabled third parties to use foreign money for regulated activities are not closed and, in fact, remain wide open?
I would agree, and I would point out that it is completely inconsistent to provide in Section 349.914A to C that there is a $200 limit on the, or a $200 registration requirement. So anything over 200 must be registered there. Yet we could have 200 million come in if your organization was was spending $2 billion, and there are foundations that have that kind of money. There are organizations, corporate organizations, that have that kind of money. So it's illogical to have these two sections right after each other where you're creating something that a freight train could drive through.
Right. When I questioned the Chief Electoral Officer about this loophole, he rebutted by citing general provisions within the Canada Elections Act that prohibit the use of foreign funds by third parties, but these general prohibitions against using foreign funds have been readily exploited by foreign actors and certain registered third parties, correct?
But my point is that yes, foreign might be prohibited under another section, but the whole idea of third-party regulation that was upheld in Harper is the idea that everyone is going to be fairly governed. And in this case, certain organizations, because of the fact they have a lot of money, will not be treated the same as other political parties. In particular, will not be treated the same as members of parliament or political parties. They will have an advantage just by their size.
Okay, and I agree with that. Now, the Chief Electoral Officer has said that this exception is necessary due to charter considerations, including freedom of speech and freedom of expression. Does that make sense to you?
Well, okay, I'm going to give you my personal and then my professional opinion. Personally, I disagree with Harper. And so I would agree with the Chief Electoral Officer that we should have absolute freedom of expression. I don't like those kinds of limitations. But that's not the law, and I have to live with the law, and so does Parliament. And Harper and all of the cases following Harper make it clear that you may limit third parties, and you may require all donations to be identified. There is nothing that I am aware of in any precedent that would suggest that there are some individuals who get to make secret donations and don't have to disclose those because of the charter. That's just not the law.
Now, you have extensive experience as a constitutional lawyer, correct?
Yes.
And is it your interpretation, your view, that if this exception were removed, that it would be charter compliant?
Absolutely. There's nothing that the charter requires with respect to disclosure. This is just disclosure. It doesn't cause someone to remain silent. It just simply requires them to disclose the fact that they're spending money during an election.
Now, it seems to me that the best approach towards closing the very large loopholes that exist that have been readily exploited is to consistently apply what this bill attempts to do for what I believe the government thinks would be the vast majority of registered third parties, and that is simply to require all third parties, instead of all but those that apply where the exception would apply, to simply set up a bank account and solicit contributions from individual Canadians. Would you agree that that is the best approach?
Absolutely. Very administratively simple, straightforward, and consistent with the law that applies to everyone else.
15 seconds.
Okay. Thank you, Mr. Chair.
Thank you so much, Mr. Cooper. We'll now turn to Madame Brière for 6 minutes, please.
Thank you, Mr. Chair. I will ask my question in French. Maître Gaumont, bonjour.
Ms. Gaumont, welcome, and thank you to all the witnesses for being with us today. We are debating disinformation, deepfakes, content online. Many are concerned regarding the measures in C-25 that they would perhaps limit comments that should be protected by freedom of expression. Do you believe that C-25 is able to strike a balance between protecting the integrity of the election process and also the necessity to not criminalize comments that are legitimate? I think that C-25 is good legislation. There is a measure on impersonations. I could find it. Paragraph B, I believe, has to do with recordings that are falsely representing what someone said. So this might be one element that is not precise enough. I'll try to find that element. But another thing is when we talk about the use of technology and deepfakes, we could perhaps talk about a sunset clause. So for now, we want disclosure. This is currently banned, but we could reopen the door to reinterpretation later if the use of AI becomes legitimate, generalized, and is no longer a problem. But I find that C-25 does strike a good balance. Mr. Chipper?
That question too, and if you can include the 10% thing.
Thank you. And I would agree with my colleague that there is, generally speaking, a good balance within the bill. I do agree that sunset laws are wonderful and that it would be a good idea to revisit it and require yourselves to revisit this very shortly, because the law, it's not just the law changing, it's technology that's changing daily, it seems. I would suggest that you do revisit one section, and that is the final section, which is section 482.01. There is a list of things that are prohibited, and one of the last ones, 482.01G, allows prosecution where someone comments on the results of an election. Now, the problem with that is that Part 20 of the Act allows you to challenge the results of an election. So I could see someone saying, I think the chief electoral officer lost a ballot box. Well, that sounds like you're challenging the results of the election. And if you had a debate over that was in a civil court and you decide, was it or was it not lost, fine. But to put it into quasi-criminal territory, where just because you have raised that question, now in a prosecution, you would have to prove your bona fides. Your good faith would be on the table. And think about it. Once the election's over, how could your commentary be an impact on that election? It's already done. So to me, 482.01G goes further than necessary and therefore would not be a reasonable limit in a free and democratic society under Section 1 of the Charter.
Pour parler là, du finance.
And now regarding funding and that 10% limit regarding freedom of expression, can you respond to that?
The 10% limit, it's not a 10% limit, it's a 10% wide open, in my view, train track. If you are a big organization with a lot of money, 10% is way more than $200. So if I am your average citizen and I have $200 to spend as a third party, I have to register. But if I have millions of dollars and I want to spend $200, I don't have to. But the more important thing is where I got that $200. So basically, I can go around and get money from people who don't want their identity exposed through the registration process. I might myself say, as a libertarian, I don't think we should have that process, but we have it. And if we're going to have it, then I think it should apply to everyone. And just because you're rich, you shouldn't be able to get around the requirement of telling the world that you gave money, you gave a donation to participate in the political process.
There's 3 seconds left. Oh,
Thank you.
sorry. Madame Normandin, 6 minutes, s'il vous plaît.
Ms. Normandin, you have 6 minutes. Thank you. Thank you to all the witnesses for being with us today. I would like to start with Ms. Gaumont regarding a comment made by Mr. Chipper regarding safety of private data, and you earlier mentioned Cambridge Analytica. We also talked about the data leak in Alberta, so if you could come back to that, that would be great. The Cambridge Analytica scandal, I think, was a turning point for Canadians and Quebecers regarding their privacy online. It led to privacy reforms, and so I don't see how one could claim that it is not an issue. You made a recommendation regarding 444.6.1 and others that the government is exonerating itself from the application of certain provincial legislations. And if parties were subject to provincial legislation, there might be some disparity depending on the province. Could you share the advantages, the disadvantages, if the parties were subject to provincial legislation? I think that the goal would be to have a pan-Canadian approach and would be similar to what applies to the private sector. And so I think that allowing Canadians the right to exercise their rights wherever they are is important. Could a party then have an internal policy that would be based on the province with the strictest legislation to ensure that they could comply throughout Canada? Could that be a good way to ensure that we are responding to the legislation by following stricter guidelines? We've heard about the Brussels effect, where the rest of the world adopted similar standards. Platforms wanted to adapt similar policies, so they all complied with the highest standards. We could envision something similar here. A BC effect or a Quebec effect, yes. Can you talk about the provinces who have internal policies that we could look to? You talked about the role that you've played in Quebec. Could you perhaps give us a picture of what's happening at the different in the different provinces? Quebec and BC are currently the leaders. They have the most updated privacy laws. I think that we're currently at this state where we need to update our legislation, and political parties need to follow the same rules as all Canadian organizations. So if we simply respected the 10 fair information principles, so regarding consent and those other elements, so following that with some amendments for political platforms, I think that would be just the start. Thank you. Can you talk about the impact of not having policies for political parties? We want there to be more transparent, but is there a risk of disparity between the different political parties and the ways that they protect people's data? Is this a risk by not having a pan-Canadian strategy and not having an obligation to follow provincial legislation? Yes, there is a race to the bottom in a way that can happen. If other parties have practices that are less optimal, less responsible regarding protecting personal data, but gives them a political advantage, well, this might lead others to lower their values in order to have similar outcomes. This could potentially lead to a race to the bottom. I have about a minute left. If we were to impose higher criteria to parties, so as was done in Quebec and in BC, would this not give political parties additional support in, for example, the implementation of internal policies, in their management of IT systems? Could parties then request support in order to update their systems? That's a good question. If you're talking about financial support, I'm not sure. Technical support, actually. Probably. And this could also build more trust. Perhaps Canadians would be more comfortable sharing their personal information if they know that they're going to be properly protected, used appropriately, and if they know what they have consented to. So having responsible policies is good. This could be beneficial for everyone.
Close. This was going to be the first time that we were all under six minutes in the opening round, but Christine is usually our best student and is usually always under 6 minutes, but I'll strive to do better in the second round. Mr. Calkins for 5 minutes, please.
Thank you. Mr. Chapur, in your opening remarks, you were listing the 4 items that you wanted to address. I think you had to stop your remarks after about the third one. I think the fourth one dealt with protecting freedom of expression. Did you want some more time to adequately address that?
I don't, because I was able to slip it in my response to
okay,
your colleague, Ms. Briere.
All right, good. I just wanted to make sure. In your opening remarks, when you talked about the voters list, you suggested that the cure is worse than the disease. Would you elaborate on that, please?
Well, all of those rules related to privacy are going to apply to all of you. You're putting handcuffs on yourself. That's number one, to keep in mind. Number two, freedom of expression in our Constitution has always been about political expression that is unlimited, and your ability to express yourself to all of your constituents could be severely hampered if we applied normal privacy considerations, because under normal privacy considerations, you can be blocked. They can say, you can't talk to me, you can't send me an email, you can't call me. To me, that is pretty close to a violation of not just the Charter, but the whole idea of parliamentary government. The idea of our system is everybody communicates on political matters, and no one is able to say, I'm not playing, I'm not going to participate. So I just don't think that privacy laws should apply in the political realm. But if they are going to, certainly they have to apply the same at the federal level. We can't have the provinces involved. That would be a disaster if you allowed the provincial laws to apply. So it has to be federal. But I recommend none. There's no need. And think about it. Thousands and thousands of people go door to door knocking on doors and asking people to vote for their favorite candidate using those lists. I think that this concern in Alberta is way overblown. There is no problem with people communicating with other people and people knowing names and addresses because it's out there. You can get it from so many different sources. The information that is important to be protected is how you vote in the ballot box. And the Chief Electoral Officer does a very good job of protecting that information. Beyond that, I don't think there's anything that needs to be protected.
Okay, thank you very much. Moving on to your third item, you talked about a different proposal for the ballot, and I wasn't sure I quite understood what you were talking about. Are you talking about a two-option ballot where you can either vote for the party or you can vote for the individual? Could you explain to me why you would change and put the party names first? I want some clarity on that.
Well, number one, because parties have been regulated, and parties are what makes our parliamentary system work. Parties are heavily regulated and provided for in the legislation. So my idea is that you take the parties, you list them, maybe in alphabetical order, it doesn't matter, and then an individual can choose a party. It'll have the name of the candidate and the party, and then that just rotates through each ballot, gets a different one at the top, and it rotates, but it's the first thing you see on the ballot. You can ignore that and say, I don't want to vote for any of the parties. I hate political parties. I'm going down to the list of independents. And then the independents would then be listed separately, rotating, but they would not, in effect, hide the political parties. You would put the political parties first on the ballot, and then all of the individual candidates would follow. But you only get one vote. You either vote for a party with a candidate name, or you go down and list go down the list to those who are not associated with the political party who've decided to run anyway.
Are there any changes that are being proposed in the current legislation where the the intended consequences are obvious? My concern is the unintended consequences being more problematic. Is there anything that you would recommend to this committee or recommend a change for, other than the ones that you've already listed, that this committee consider?
No, I think I've given you all of the biggest one, though, and this is something that the two decisions from the court have highlighted over and over again. My recommendation, pull the chief electoral officer and commissioner out of any discretionary role. Their neutrality is protected by them carefully following a statutory provision. They need to be restricted to making those kinds of decisions, applying the statute as written. They should not have a discretion with respect to party policy on the issue of privacy. I mean, it just doesn't make any sense.
Thank you so much. We'll now turn to Madame Kaibaga for 5 minutes, please.
Thank you, Chair. I'd like to also welcome our guest today, and we welcome Mr. Lowen as well. Mr. Chipper, just back to you a little bit. Regarding your concerns about criminal penalties for conveying false information, the threshold in the bill is intended to prevent capturing personal opinions or parody and to moderate any potential charter concerns. With that in mind, can you comment on the threshold contained in Bill C-25 that requires a person to know the statement is false and to make it with the goal of undermining trust?
The problem I have with the 482.01 is not that we shouldn't have some rules. My concern is just one area, and that is Part 20 gives the right to challenge the results that have been stated. And in my view, by giving the commissioner the option to charge, it creates in my view, a high standard for the individual to try to prove, particularly if it turns out what they said was not true. They may have someone who reported to them. They shouldn't have relied on that report. They went forward. It's just the problem of having to defend oneself for no good reason. There's no good reason to stop someone from commenting on the results of an election. It just won't impact the election. So let's not create an administrative burden for no purpose.
I think many people who have commented on this specific issue would have a divergent view on that, because the goal is to keep Canadian trust and make sure that there's no false statements being made about candidates and no interference on that. But I do want to go to another question. Just because of time, I really do want to get to my next question. With respect to the concern that you have raised around third parties using their own funds. There are still reporting requirements for third parties with respect to the source of the funds. Reducing the 10% threshold would prevent third parties from using their own funds to pay for regulated fundraising activities, even if the funds are generated entirely in Canada and from Canadians. This would also prevent them from engaging in regulated fundraising activities and consequently from exercising their charter rights to freedom of expression under subsection 2B, freedom of association under subsection 2D, and the right to vote, section 3. As I'm sure you are aware that Canadian courts have a history of scrutinizing restrictions on third-party participation in elections, as illustrated in, for example, Harper versus Canada, Attorney General 2004 regarding spending limits, and Ontario Attorney General versus Working Families Coalition Canada, Inc., and 2025 regarding limits to political advertising outside of election period. Although the Bill C-25 takes many important steps to close channel for dark and foreign funding, it also strikes at an important balance to ensure that Canadians' charter rights are respected. So I'm hoping that you can speak on the importance of protecting our Canadian charter rights.
Absolutely, and one of those rights is equality, and certainly by using 10%, That's just not equal. So if you wanted to use $1,000, $10,000, $100,000, and say that's the limit that can be given by a third-party organization that is not using some bank account where individuals deposit money, I'm all for that, because then it would apply to everyone equally. But 10%, when you have such a diversity of third parties, certainly is not equal. And so my view is that's a limitation on freedom of expression that simply is not justified in a free and democratic society.
Do I still have time, Chair?
40 seconds.
40 seconds. Peut-être si je peux entendre à vous, Madame Eve.
Ms. Gaumont, you talked about the ways that we could improve digital participation. If you have any suggestions in about 20 seconds. There needs to be a registry of political ads, needs to include more information, including an Elections Canada registration number and information on the ads that were used. Thank you.
Madame Normandin, 2.5 minutes.
Ms. Normandin, 3.5 minutes. Mr. Lowen, you talked about the importance of names and how they reflect the geographic realities of ridings, and you talked about historical names that and historical names. And if you could talk about how a historical name can be linked to geography. If someone founded a city, for example, or a town, should we consider the importance of that historical nature that had an impact on the geography of certain ridings?
A mix. Look, I think there's a whole series of processes that places are going through right now to change names, to remove people's names from things. For example, my old hometown of Toronto is going through this with Dundas Street and other things. I think it's an interesting exercise. I think the point more generally is that when we add names to things rather than taking them away, we add to our history. And I think we've spent a lot of time in the last number of years thinking that we could cleanse ourselves of things that have gone wrong in the past by removing names rather than just coming to terms with what happened when it happened. And I think for the commissioners in this case, the belief was that by representing the important historical and contemporary Indigenous communities that are involved with some ridings and that have the right of being represented in Parliament, that was a positive way of recognizing Canada's Indigenous history and Indigenous present, rather than, the more I think less helpful exercise of simply removing people from things, thinking that it will somehow change the past when it doesn't change the past or the future.
Merci. Et rapidement, Maître Gaumont.
And briefly, Ms. Gaumont, on online activities by political parties and transparency, can you talk about what's being done thanks to the Elections Act? Is there true transparency, or is that also part of the shortcomings in the bill? It's not included in C-25, so it could be considered a shortcoming. There was a registry. There was a bill in 2016. I think that we need to work with social sciences researchers to really understand the needs and then legislate and codify. Thank you very much.
To be cruel, given the time, I'm going to do 4 minutes to each for each member because we have to suspend. So I apologize for my cruelness, Mr. Jackson, and please proceed.
You're 2 weeks apart, Mr. Chair. I thought you'd be in a better mood. Oh, dear. Anyway, thank you to the witnesses for being here. I sincerely appreciate your testimony today. Mr. Jipper, just to pick up on your second point that you mentioned in your opening statement about the lack of judicial review for the commissioner in certain of their new powers coming forward in this piece. I just wondered if you'd elaborate a little bit more on what some of the unintended consequences of that may be for individuals in Canada should this come into effect as it currently sits in the bill.
The problem is the decision in Longley, which is an Ontario Court of Appeal decision, said that care should be taken to ensure the impartiality of this critical public role. That's the role of the chief electoral officer and the commissioner, we can add. So if we have an individual that is intended to be neutral, becomes the prosecutor, then we have a situation where there will be a perception that the party is not neutral. So the way to bring back a perception of neutrality, because the commissioner does at times have to prosecute, is to put judicial review of that decision so that there can be better or more confidence in the decision, a very powerful decision, because if it was done in the criminal area, it would be absolutely unconstitutional. But because it's administrative law, the Supreme Court has allowed this kind of law to be in place. In my view, it should not be in place in election laws because of the important neutral position the commissioner and CEO must play. And the Court of Appeal has effectively said that's mandated. And so my recommendation is that this committee recommend that the rule in 510.01 apply everywhere. Always require a judicial oversight. You have to ask the judge with an affidavit where the commissioner says, I have evidence that leads me to want to ask questions of this individual. I want to have permission to do that.
You don't see there being any challenge of that being overly burdensome of a requirement to have in place?
No. It's what happens every day when the police deal with everything from drunk driving to a theft and possession of stolen goods. So it is a normal part of everyday policing.
Okay, very good. On the piece, we discussed briefly about questioning an election result. Do you have any examples of somewhere where someone has knowingly questioned an election result? Or I'm just trying to get around are we creating a solution for a problem that doesn't really exist here?
And I'm not aware of any, and more importantly, I mean, there have been, over the last 40 years, I've heard of cases where someone took a ballot box home. And what if there was an allegation and then it turns out it wasn't true? Then did they act in good faith? Did they have enough information to make the allegation? And to me, why would you do that when, in fact, it can't have any impact on the election because the election's already done?
Well,
so I'm just saying take it out because the election's done.
And in fact, the chief electoral officer confirmed that it's actually normal process for ballot boxes to be taken home in some circumstances by deputy returning officers for storage until they can be opened and counted. Yeah. So, I mean, if someone is
when they come back with more ballots,
yes,
then we're issued, it sometimes raises questions.
Yes, exactly right. No, I thank you for that testimony. How am I doing for time?
9 seconds.
Okay, well, thank you very much.
Thank you. I will be equal in my cruelty. Ms. Fancy, 4 minutes, please.
As always, thank you very much through you, Mr. Chair, and thank you to the witnesses today. I'd like to talk primarily with Mr. Lewin today in regards to nominations, unique official agents, and long ballots. So with our bill, with C-25, it contains kind of two primary measures to deter these unruly long ballots. Notably, voters can only sign one nomination paper, and that each candidate in a riding will also need one official agent. I'm wondering today if you could speak to the importance of including both of the measures that we have proposed in Bill C-25. And what you think some of the merits of each of these measures are individually, and also what you think is important or why it would be important to include both. Thank you.
Thank you very much. I had last autumn, I believe, on this long ballot measure, and I was glad to be included in that. The long ballot effort is an effort not to enhance Canadian democracy. It's just an effort to gum up the works by people who have tried to reform the electoral system and have lost at every occasion that they've done that. That's just the political reality of it. I'm glad you're trying to address it because I think it's a nuisance and it's burdensome to elections. On those two particular measures, limiting a single agent for single candidates, I think, is a very advisable thing. People may have a hard time convincing 200 other people to get involved in their shenanigans in trying to create long ballots. On the issue of an individual signing multiple candidacies, I think there's a potential for it being a problem only because we all know people in our communities who are local notables who help anyone out, and you can imagine them being approached 1 month to sign a person's nomination. They sign it for the person to be on the ballot, and then they sign another one a few weeks later, and they forget that they've done it. So the potential for that to be not restrictive in creating candidates, but just to create problems after an election that further government the works, I would be concerned about that. But to the degree that the parties here can just recognize that these long ballots are not helpful to helping voters find sincere candidates on their ballots, I think it's highly advisable that you do something.
What about the last part of the question regarding having some of these official agents doing with multiple candidates?
Yeah, so to be certain, I think having allowing people to only act as an agent to a single candidate per riding is reasonable. I think that the restriction of if you try to have a single agent, if you say that an agent can't work for multiple candidates across ridings, it becomes restrictive especially for startup parties.
Thank you. And I come from a rural coastal community where sometimes there's only 1 or 2 people that have that type of notability around the area, so I can see that piece. My second question is, can you share your thoughts regarding some of the provisions with Bill C-25 that seek to prevent anonymous and sometimes hard to trace contributions by prohibiting political entities for all of their activities and third parties for regulated political or election activities from accepting contributions in the form of either cryptocurrency, money orders, prepaid payment products. So I'm wanting to know what you think that if this measure will help ensure transparency in our political financing regime.
I'll just make 2 points on it. One is that I think that trying to regulate the medium of exchange will become increasingly difficult. The crypto stuff is all a gray area, but there are methods of payment which are becoming more acceptable and regularized. The bigger challenge for you as a committee and with bills like this is the following. Whatever one thinks about restrictions on third parties, to Mr. Chipper's point, it is the law. We've established that we're allowed to limit the speech of third parties so that elections are mainly fought between political parties. The way that's normally done, and you see it in this bill, is by regulating what individuals or organizations do, saying these ones can speak and these ones can't. And the second is that is, say, legal entities or persons in a sense. And the second is to limit spending with the notion that spending is what equals speech. It's very plausible that we're getting into a world in which it's not people you're trying to regulate, but agents, that someone is setting up a series of agents online which are then distributing information. They're not people and they're not organizations. They're something else. That's one. And second, they do it at a cost basis close to zero. So the idea that you will regulate speech of people who shouldn't be allowed to speak during elections by identifying individuals or organizations and by limiting their spending as a means for doing it is, pretty soon that we'll be fighting last year's war. And that becomes a real challenge for you from a regulatory perspective.
Thank you so much. I'd like to thank our witnesses for appearing today. The committee will suspend for a few minutes while we set up our next panel. Thank you so much.